My name is Carol Self, and I'm the Director of Permanency for Child Protective Services. And what we want to do in this next session is kind of pull together. I know that y'all had a pretty dynamic lunch, and it's after lunch, so you're going to start feeling nappy. So what we want to do in this next 50 minutes is we're going to put y'all to work. And it's kind of like a pop quiz. So all that meaty information that these folks shared with you before lunch about HIPAA and our confidentiality requirements, we want to kind of put those into scenarios that y'all might experience in your kind of day-to-day work and come up with kind of the answers for how you would put this into practice. So what we're going to do is on your tables, there is a scenario. There should be 2 sheets of paper. One says scenario 1 and one says scenario 2. And along with the scenario are some questions. So each table, we are going to give you about 5 minutes to discuss at a table the scenario and also to come up with what you think the appropriate answer to the question is. You need to designate a reporter at your table, because then once we everybody's had an opportunity to review the scenario and answer the questions, we're going to share out loud kind of where you came up, what the answer is, and potentially kind of your justification for your answer. And then our professionals up here are going to provide either some more insight into the answer to the question and or give you some corresponding law or statute that supports your answer. Does that make sense? Any questions? All right. So we're going to start with scenario 1. And as I said, we're going to have it up here on the screen. You also have a copy of it on your table. But I'm going to go ahead to get us started off. I'm going to go ahead and read this scenario, and then we'll have 5 minutes for y'all each to discuss it. So 10-year-old Lucy recently entered the child welfare system and is in the legal managing conservatorship of DFPS. CPS placed her with a foster family as there are no relatives available to care for her. Although the law allows Lucy to stay in her original school or school district, CPS determined it was not in her best interest to remain there and has withdrawn her from the school district and enrolled her in a school in the foster parent's local district. The CPS caseworker learns that Lucy is eligible for special education and has an individual education plan that was developed by an ARD committee at her previous school. The caseworker and Lucy's foster mother each separately contact the special education staff at Lucy's previous school and ask for a copy of her IEP. They also contact the new school and ask to be included in all future meetings at the school regarding Lucy, including any ARD meetings. So that's the scenario. And on your table, on your sheet, are the questions, and some of y'all have different questions. Y'all aren't all answering the same question.
Oh, no.
No. Tricky. We have about 4, I think there's about 4 or 5 questions that all belong to this scenario, and y'all each have one of those questions. So I'm going to time y'all. Y'all have about 5 minutes. And as a reminder, one person is going to answer. Be prepared to give your response. All right? Okay, so we have some Vanna Whites in the room. They're going to pass around mics. And so our first question is, can the previous school's special ed staff provide the individual education plan to the caseworker without the explicit permission of the biological parents? Raise your hand if your table had that question. All right, we need one person, one table to volunteer to give us your answer. Just stand up so we know who wants to do it. Oh, we got one over here.
I'm going to say yes because
It's the same scenario. We all had the same scenario with Lucy.
Different question.
Just different questions. So 10-year-old Lucy, who's in foster care.
so at this point the department is the temporary managing conservator. So yes, they would have access.
Okay. So a follow-up question to that, so a different table that had that same group of questions. Can the school provide it to the foster mother without the explicit permission of the biological parents?
Yes. According to the Uninterrupted Scholars Act amendment, they can.
All right.
All right, yes.
Any questions with that one? Does she need that form? Does the school need the?
Oh, wait, so the Uninterrupted Scholars Act, FERPA, was the previous question about the schools giving it to the caseworker. But now the question about providing it to, about the foster mother, the answer is different than uninterrupted scholars. I mean, there's an additional answer.
Representative of the agency. Sorry. Wouldn't the foster parent be a representative of an agency so that
Yeah.
would also apply?
Yes, but yeah, you're right. The additional answer was just that person should be named on the 2085 forms, the one that's
right.
the placement authorization, and then specifically the one that's the designation of the education decision maker. So the school is within its rights to ask for that form before it shares, as far as we're concerned. But they could also, I believe, under FERPA say, this person is representing the agency, and so, but they would want proof that you are representing the agency, so the form is the proof.
Question?
I was just wondering, does it matter that they withdrawn, so that could the previous school district say that child has withdrawn, and we've sent the paperwork to the new school district, you're gonna have to ask them?
Everybody hear the question? Well, the question's about the student was withdrawn from the first school. So the student is moving from school A to school B because they had a change in their foster care placement. And so hopefully our caseworker has withdrawn them promptly from school A, because otherwise they're going to show up as truant in school A because they're not going anymore. Then we've enrolled them in school B. So your question was, might school B say, or might school A say get the records from school B, or vice versa? Yeah, I suppose they could, but this is more about legally, are we entitled to them? I don't know if they've already been sent, whether school A, if they don't have them physically, I guess they can't give them to us, but through T-Rex, it's all electronic, right?
Yeah, but we would still be entitled to them.
Yeah,
So.
so be entitled to them from either one.
Even if the student wasn't enrolled in school B, if they have the records there, the access is still the same.
Okay. All right.
Quick question.
Oh,
Once they're sent over to school B, is school A required to keep a record even though?
And that's going to depend on your school district's records retention schedule, which under state law they have to maintain. If it's grades, I would say K through 8, they probably aren't going to have those records or maintain a copy of them.
Okay.
Grades 9 through 12, probably.
Is there an acronym for that policy?
There is not. No. Your RA, records retention schedule, RRA, yeah.
all right. So next question. Same scenario with Lucy. Is it appropriate to allow the foster parent and the caseworker to attend future ARD meetings? Who has that question? This front table. Yes. Wait. Yes. Why?
Yes. Well, that's good.
Had to throw
Uninterrupted scholars?
uninterrupted scholars?
No, the ARD meeting attendance is generally governed by IDEA, as the speakers that had gone before us this morning talked about. And under IDEA, generally it's going to be who's ever acting as the parent for the child, so it's going to likely be the caregiver. But the caseworker can also be invited. I don't want to answer the second part. Other people can be invited if the person in the role of the parent invites them. I heard the speakers this morning say that the CPS caseworker could be automatically allowed. And so that's a reading of the law that we like at DFPS. My understanding was that the person acting as the parent has to invite anyone else who's going to come, but we always think this caseworker should be able to go. So some of the areas of law are not super clear cut regarding some of those things, but absolutely the foster parent.
And caseworker.
And caseworker.
So, can Lucy's CASA volunteer attend the future ARD meetings?
Yes.
Yes, if invited. That would be our interpretation, is that the CASA would be invited by the person who is acting as the parent, so the caregiver. Really, the Texas law requires everybody to consult in situations where you have a child in foster care. So it's under the surrogate parent law where it talks about if the child has a surrogate parent, they're supposed to consult with the caseworker and the CASA and the attorneys ad litem and the guardians ad litem. So hopefully it's a collaborative effort.
I have a question here on that. If the CASA worker is also the guardian ad litem, which category does the CASA worker fall into?
Well, the guardian ad litem probably. That one is like trumps the other one because it's stronger. It's usually got a more robust court order or something.
Yeah, the guardian ad litem would have all the powers and duties that fall under the guardian ad litem, if they're a CASA guardian ad litem.
But I was asking which category then do they fall into if they are the guardian ad litem?
Well, it doesn't really matter in terms of going to the ARD, because in either case they can go if they're invited to go.
Okay.
Because otherwise, a guardian ad litem doesn't have an automatic right to go to an ARD. It's who's ever acting as the parent is supposed to invite the other people that they think should be there. So they could invite either the CASA or they could invite the guardian ad litem or both if they're different.
All right. Can the IEP be provided to Lucy's CASA volunteer? Back table over here.
So that was our question, and the answer to it from my experience as a CASA for Collin County, who's also the guardian ad litem, is yes.
Correct?
Right.
Anybody want to share?
Well, we were talking about this during the break, that a lot of it depends on what the court order appointing the person says. And so whether it's a CASA court order appointing the CASA or appointing the CASA as a guardian ad litem, that if the order says the person can get access to all the information about the child, then they can get the IEP and they can get all the information about the child. So hopefully, I mean, if the court order doesn't specifically say, it'll say something like all records. So that's all records.
Mm-hmm. So what if the guardian ad litem, including CASA acting in the role of guardian ad litem, and the attorney ad litem disagree with decisions being made about the child's education, including special ed? Do they have a right to get the information or records?
We said yes.
We said yes, we have that question as well.
All right. Does everybody feel pretty comfortable with those sets of questions? And the scenario?
That it's look at what the court order says. So that's the nutshell. If it's someone who's appointed by the court to be in that child's life, that order is your Bible about what they're allowed to have. And so the school is allowed to say, I don't know who this person is. Let me see your order of appointment. And then the school's allowed to say, okay, I agree with you. It says you get all records, so we can give you the records. That's the takeaway on those questions for all those appointed people.
All right.
Everybody, you need to speak in a microphone, whether you can be heard or not, so that you're on the video. Okay? Thanks.
All right. So let's move on to scenario 2. So this one I'm not going to read out loud. So if y'all want to take 5 minutes, read your scenario. Same circumstances, everybody has a different sets of questions, and then we'll do the same thing. All right? So you got 5 minutes. right, y'all ready? Okay. So, question 1. Can Counselor Brown provide the counseling, mental health information, and/or records to the attorney? Wouldn't HIPAA prevent the records being shared?
Who is the attorney representing?
The child.
Okay, because it's not in the subject.
Either one. I think we decided that it was would be the same question if it was the attorney ad litem or the guardian ad litem. Oh, you meant like, is it representing the parents or something?
Both the guardian ad litem and the attorney ad litem for 16-year-old Jake. So the attorney's representing Jake. Can the counselor provide the counseling mental health information to the attorney? And does HIPAA apply? Who had that question? Anybody want to take the mic and answer it?
We said yes, that the attorney can get the records, and HIPAA would not prevent the records being shared.
Okay.
Why?
Because you said so.
Good answer.
Sorry.
John, do you want to?
Yeah, HIPAA does not apply here because it's not a covered entity. Remember, for HIPAA to apply, you have to be a covered entity. And schools under FERPA, okay, are exempted from HIPAA. So FERPA rules apply.
Yeah.
And while we're at it, DFPS is also not a covered entity under HIPAA. There's a lot of misunderstandings about HIPAA and who's covered or not, but as John is saying, you look at what the entity is and what they do, and DFPS does not meet the criteria of being a healthcare provider who bills electronically under HIPAA, so we're also not a covered entity under HIPAA. That's not the question. I just thought I would throw that out there while we were talking about HIPAA.
Can I throw another twist in that?
Sure.
So we're talking about FERPA versus HIPAA. What if the school was a private school? Okay. What's that? Well, it is a school, but
Hold up. We need to get folks in the mic. So, Lee.
Right there, the other side.
If I am remembering correctly, FERPA applies to schools which accept federal funding. And if the private school does not accept federal funding, FERPA does not apply.
100.
Yay.
And I haven't forgotten everything.
I think she's a secret expert there.
She's a plant.
That's right.
All right. Question 2. What about sharing counseling records with the CPS caseworker? Can the counselor do that? Who had that question?
Yes, they can share with CPS as well because, like, the school is not a medical entity. So yes, they can share.
Okay.
Right. So under FERPA, it's a FERPA record since it happened at the school. It was created at the school according to the things Montgomery's told us. And so then under the Uninterrupted Scholars Act, USA, that amended FERPA to make it clear, caseworkers can get school records. It's a school record that the caseworker can get.
Question 3. What if instead of a school counselor, Jake was receiving services from an outside mental health provider at the school, such as Communities in School, or a private therapist that was coming to the school to do the therapy? Can that outside mental health professional provide the counseling mental health information or records to the attorney? Does HIPAA come into play at that point? Who had that question?
Yes, we said HIPAA does come into play.
Okay.
What was the answer? I'm sorry, I didn't hear that.
We said yes, that HIPAA does come into play in this scenario since it's an external outside mental health provider.
Why does HIPAA come into play?
Well, they're billing and it's not part of the school record.
Okay. Let me throw in this.
No,
If a counselor, no, because you're probably right in terms of this, but The key here is whether the counselor is acting on behalf of the school or under contract with the school.
Okay, that's a wrench.
So if...
It's a contracted provider.
What's that?
It would be a contracted provider, so it would still apply.
Right, I'm just adding it.
Right. Okay, I passed.
So even if the counselor is seeing the kid in their own office, but at the behest of the school or under the contract of the school, that would still be under FERPA, right? But if the counselor is not employed by the school, contract school, not acting on behest of the school, then that's the counselor's record, and that's HIPAA. The counselor has to abide by HIPAA in order to accommodate the release of those records.
Very well said. You got 100.
I get 100.
Has anybody experienced that? Where you have a kid that's receiving some kind of mental health services in the school by somebody that's not employed by the school or contracted by the school?
Does the fact that happens during the school day in a school building impact that?
It depends on if the counselor is acting under the contract with the school or on behalf of the school. That's the key issue there.
So it's the counselor's relationship with the school that comes into play, not the fact that it's even in a school setting. Because as John mentioned, that the service could be provided outside of the school, but still at the behest of the school, and so it would be FERPA and not HIPAA.
Right.
Did I say that right? Okay.
So slight variation. So what if the counselor or the behavioral therapist is contracted by CPS and they're acting at school?
Right. So that means the relationship, so the counselor doesn't have any relationship with the school, so therefore it is HIPAA that comes into play, not FERPA, because the school has nothing to do with it. See, I'm just taking over y'all's jobs.
No, you're doing good. These are hard. These are really confusing questions.
I just wanted to say, from my experience working with schools in North Texas, schools do not routinely or very often allow an outside therapist to do therapy in school during the day. So I don't think that's a common situation.
Yeah. Question over here?
Hold on, get the mic.
No, we were just saying, we're in Dallas ISD, and so we do have youth and family, and they're actually located in the parking lot of the teacher building. So if we have a student who has an emotional breakdown that's getting therapy through them, they actually do come to our inside of our building and sometimes have to work with the student quite regularly because they are so closely located with our school.
But they're actually partnered with Parkland, so they are outside provider. They are partnered also with Dallas ISD. So I know that it's kind of an unusual relationship, but they are our go-to people for ongoing therapy and things of that nature. But there is physical doctors and things like that, psychiatrists. But like I said, they are, like Ms. Whitfield said, they're also in our parking lot, and they come into our buildings fairly often.
We're counselors, so.
Yeah.
Right.
Wow.
So one thing that's important to remember is that the duty to release properly is on the party that has the records. So if there's a healthcare provider operating out of a trailer in the parking lot, their lawyer is telling them what they have to comply with. And so that's the one thing I always want to remind people, that we can all agree amongst ourselves about different scenarios, but ultimately we don't get to say, because that healthcare provider or that school, now that school might call Montgomery, but he's going to probably say, here's what the law says. However, your own school attorney makes the ultimate call for any school decision. And so the healthcare provider will know if their lawyer says you're HIPAA covered, they're HIPAA covered. And it doesn't matter what we decide here in the room that we think it should be. They're going to say, I need a HIPAA release. and then you're going to have to find one or get one or figure that out. Same with the school. If a school says, I don't care what you learned at a workshop, we think that this is not something we can release without the proper consents. I tell our people, you can call me and we'll try to work through it, but it's the party who holds the records who has the legal duty to protect those, and so they're going to follow the law they believe they're supposed to follow and require of anyone who wants that record what they think they're supposed to get, ultimately.
Yeah, I'd mentioned earlier that the requirements for disclosing patient information records are imposed on the healthcare provider, right? And also, just to make sure we're getting the same language, because remember I said before how people seem to use the words consent and authorization synonymously, right? They're much different. Authorization is really specific. Name, place, for purpose, right to revoke, and so forth. That has to be in writing and signed. Consent is something looser in this world of records and so forth. So what you're looking for is authorization, and the person with the records who would be releasing the records has the burden of having the authorization to release those records. That make sense?
So they're going to ask of you what they believe their law requires, and if their law believes that it just requires consent, then they'll give out the records with just someone's consent. But if they believe under HIPAA, for example, where they need this authorization that has all these particular components to it, then they're the one who's going to ask for that. And if you think it's more than the law requires, you just have to try to work with that entity to meet what they're asking for. Like substance abuse records, really difficult to get those. So we have to have a special authorization form when CPS is trying to get substance abuse records.
Not only that, but also for mental health records. You know, one of the things that I have found helpful, and I neglected to mention that, but the Attorney General's office has a form that says authorization to disclose protected health information. Okay, it's basically a HIPAA form, but it has all the elements there. And maybe I'll give the link to Diane afterwards that you can get it, but it really is a nice kind of check-off list as to what is necessary under the law in Texas to get authorization, or for the provider to be authorized to release a patient's records.
All right. So, can Counselor Brown, or the school, because we've established that Counselor Brown's working with the school, provide the information to the RTC? If so, why and how? And does HIPAA impact the situation? Who has this question? I got a hand up over here, and we'll let two comment. Go ahead.
So I'm not 100% on this.
It's all right.
But I believe the answer to the first question, can Counselor Brown provide the information directly to I'm assuming directly to the RTC? I believe the answer is no. And I'm not certain on that. I'm guessing I'll get some guidance here soon. And then if Counselor Brown is working directly with the school, employed with the school, then if I am understanding it correctly, HIPAA does not apply, isn't it, under FERPA?
Yeah.
Okay.
Okay. And y'all had the same, do y'all want to add anything or give your?
Well, our confusion was we aren't really familiar with exactly what a residential treatment center is and what the relationship is. So my argument, which I was making stuff up. So I'm also a lawyer, but not in this area. I'm mainly a CASA volunteer. But is that a residential treatment center, it might be like a group home appointed by where custody was granted to that RTC to have the day-to-day custody of the child. And so they, in that view, I think they would be in the place of the parent and they would be entitled. But we weren't totally sure what an RTC was.
Yes.
And first of all, we didn't know what RTC, I thought maybe Resolution Trust Corporation. Going back to my banking days, but no, they've been gone a long time, so.
So I guess we should have clarified the acronym for that one. Yes, residential treatment center is what we're.
And I also don't have any background really in children's rights, which is why I came. Mine is healthcare. And our thought, too, as Ms. Brady said, was it's what the lawyer tells Counselor Brown. And in our case, I would be looking at those questions and lining up the very specific request to what is reflected in Brown's records and not providing anything else that Brown might have from other healthcare providers, other incidents, other things unrelated to those questions, because HIPAA is very strict. And I took it from, of course, a HIPAA perspective that I don't know what FERPA does, but if I were giving someone advice who's giving mental health treatment, that's what I would be guided by.
But if Counselor Brown works for the school, I thought we determined that her records are under FERPA, and HIPAA wouldn't apply if she worked for the
You've said that, but I didn't know that when I at the table conference.
I didn't know it either. Montgomery taught me that.
Yeah.
Last week.
So my whole thing, though, is that, that license is directed under the Texas Health Code as well.
Right.
And so you've got a potential conflict.
Right.
And I would always go for the lesser production because of the fact that HIPAA is so strict. And Texas has its own HIPAA, which is narrower.
Texas HIPAA,
So,
right. I know.
John,
further complicated.
you have a position on that, I know.
You mishandle records, HIPAA records in Texas, and they have a provision that's not in the federal, and that is you can be liable for civil actions rather than just a fine. So, and anyone, as I said before, anyone who comes in possession of protected health information, even if you're not the original mental health provider, is automatically classified as a covered entity. So,
yeah, the state law complicates. Okay, so a couple things though is that for a child who's in our conservatorship, we would be the one who would be allowed to consent to that release of the counselor's records. So our first line would be, and this is the DFPS position, our first approach would be, we filled out the form, like you mentioned, we've sort of given that residential provider our authorization. They're acting as our agent. They're caring for that child on a day-to-day basis. So they'll have this form that says, you now have the authority to go and get records for the child. If for some reason the school wasn't comfortable with that form and said, no, we want the consent of the parent or guardian, then we'd say, well, that's us too, so give us that form and we'll sign that form, and then that way the information can be shared. So there's a couple ways that you could go at it, but
And we specifically kind of talked about, because residential treatment centers are oftentimes when we're talking about foster care, we're talking about foster parents. And so residential treatment centers are another type of provider that CPS sometimes places kids in, especially some of our high acuity needs kids who need a more restrictive setting and that have other behavioral interventions happening in the facility, but they are still the designated placement that CPS is contracted with to provide those services. So
that was the only reason why we would say yes rather than no when you first answered.
Right.
Because of that. But again,
because they're seeing it just like you would a foster parent. They're still who we're placing that onus of delivering the day-to-day care of the needs of the
but we
child.
know that schools don't always realize that.
Yeah.
And so
have any of y'all experienced real life situations where you've had difficulty obtaining records on behalf of a child, or your role was unclear to either the school or about being able to provide y'all that information? Has that happened to y'all?
I've been questioned on it, but because of our super duper fantastic training at Dallas CASA, I knew to always carry a copy of my order and my photo ID anytime I go anywhere in my capacity as a CASA. So when they said, you want what? That, we don't know if we can give that to you. I said, Thank you. I am so glad you're so careful, but let me direct you down to this paragraph here in the judge's order, and it had to go through several layers, but I got the records.
In particular, that photo ID is very important in Texas.
Yes. Yes. No, it is, because it's like, well, it doesn't, but you can't vote with it. But no, I mean, because I got that too, because when it finally went up to administration upstairs, they said, well, don't give it to her just because she's got an order unless she's got CASA photo ID.
Wow.
So, yeah. And then it was like, okay, good.
So the statute, and one thing when we talked earlier about the first scenario that I forgot to mention, is there's specific state law that's related to guardians ad litem and attorneys ad litem. So when a CASA is appointed as a guardian ad litem, and that law specifically says access to child and information related to the child in conjunction with an appointment as an AAL or a GAL, the custodian of any relevant records relating to the child, including records regarding social services, law enforcement, school records, et cetera, shall provide, that person can get them. So you might need to show the court order, but the statute says if you have a court order appointing you, any custodian of records can give you those records.
And FERPA is going to give the education agency the authority to make sure the person is who they say they are. So if you want access to the records, we're going to ask for your ID.
Yeah.
Of course. They wouldn't be scary.
All right. So I hope that from this morning's conversation about getting into, kind of the differences between FERPA and HIPAA and some of the DFPS confidentiality laws, that this exercise kind of helped you kind of put those pieces together so that you kind of see how they fit in real life scenarios with what, y'all do kind of every day, and that y'all found this helpful. But I think are we taking a break? So we're going to take a break, and we'll be up here if anybody has additional questions. But thank y'all very much.
Thank you.